if they come up with who the leaker was, they're gonna drop it at a very, I don't know, like the third week of August, I feel like, or the fourth week of August, when there's all the Supreme Court reporters are on vacation and no one's, I get the sense they're going to want to be quiet about that. But do we have a real sense of what the friction is? Because it seems to me that is contingent upon who leaked it, right?
Right.
I mean, if it's one of the liberal justices' clerk, someone's going to be bad. But if it's one of the conservative justices' clerk, I would imagine John Roberts is going to be very, very angry at that person.
I think I'll start by saying that all the justices will not be happy with whatever clerk did that. And I think that goes for liberals and conservatives alike. They really prize their ability to hold these sorts of discussions behind closed doors. And I think that for them is an institutional concern that supersedes the sort of partisan rancor. They don't want to work for a place for the rest of their lives where they have to worry about this sort of thing. But beyond that, I think to your question more specifically, we know this, sort of through a little bit of Kremlinology. We've had public remarks recently by Justices Alito and Justices Thomas, where they say that either through omission or directly that this court isn't as well functioning and as collegial as it used to be. Alito, when he was asked about the leak the other day, he obviously declined to speak about it in general terms. But he refused to say whether the justices could even sort of get a friendly lunch together. And when you look at the justice's past remarks in these sort of law school events, they usually say, at the end of the day, we're all friends and, we were able to put that behind us. So his omission there was telling. You also have Thomas saying that, this is the most, this isn't the court that he started out on, the Rehnquist court, which was from roughly, for him, 1990 to 2005. He portrayed that as a very collegial, friendly court that he could trust, that he could get along with. The implication being that the current court, headed by John Roberts, is not that. So I think that while, obviously the leaker could have been any of the clerks, they're certainly assuming that it was a liberal clerk, and they're assuming that, this is part of what they see as a liberal left attack on the courts in general.
They're trying to project, at the very least, that they're assuming that it's a liberal clerk.
Right. I think that, for them, their logical conclusion is that the only reason you would have leaked this is to sort of embarrass the right to gin up opposition to that. And, a liberal clerk may well have thought that. There is also a strong, sense that it could have been a conservative clerk trying to, pin them down.
Well, we do know there were prior, leaks, I guess, as to what was going on, right? There was a couple to the Wall Street Journal, and that was not by a liberal clerk. They specifically, the Journal ID'd this person as someone who was close to the conservative justices. That would not have been a liberal clerk.
Right, and I think we can assume in general that a liberal clerk is not chatting it up with the members of the Wall Street Journal editorial board.
Correct. I think
they've gotten leaks before, both in this recent case and in Bostock, which was the LGBT workplace discrimination case recently, that suggested, that the conservatives were sort of betraying the conservative legal movement.
So would a clerk speak to a reporter without permission, without the knowledge of the judge that they're working for?
I have a hard time imagining that any justice would sanction a clerk leaking something to the press. I mainly because I assume that if they actually for some reason felt that strongly, they would simply do it themselves. I do think that, for the court, this is a court that sees itself not as part of the rest of the Washington political establishment. Obviously there are a lot of people who disagree with that, but they see themselves as sort of a part. And the idea for them that they could be part of the leaks and spin dynamic that they see in Congress, that they see in the White House, that's something that I think that they're uniformly against. And if a clerk did this, they probably did it thinking that they would have some sort of impact on the court's decisions beyond what a justice could accomplish.
All right. So let's, with that said, let's go through some of these cases that are going to be pretty serious. I think obviously Dobbs v. Jackson's women's health. I think everyone is familiar with the implications of this. Certainly, if they've listened to this show, they should. And that would be there is a potential, if that brief that was leaked is the brief, Roe v. Wade is done. Period. Frankly, in the event that they find for, I guess, Dobbs, if the 15-week minimum, if the 15-week ban stands in and of itself, it is de facto, regardless of what the court says, a review, basically a reversal of Roe v. Wade, because Roe v. Wade had a specific, particularly with Casey, had a specific window in which you could not ban abortion, right? I mean, so and I think we know the implications of that. Could it get any could they go any further? I mean, they're not going to go any further than what we saw in the Alito thing, but the Alito thing opens up the door for Obergefell and maybe Griswold, which is birth control and marriage equality.
Right. There are two answers to that question, and one is specific to abortion. Now, I think a lot of people think that overturning Roe v. Wade would be sort of the logical endpoint of the anti-abortion movement, that once they return it to the states, it would then be something that they pursue on a democratic means. Something that Alito alludes to throughout his opinion, but doesn't really, very consciously doesn't get to in the weeds on, is whether or not a fetus is a person under the 14th Amendment, and whether or not they have legal personhood. And this is something pushed by one wing of the anti-abortion movement. It's not something that has unanimous agreement on them as a viable legal strategy. But it is something that they have suggested that if they do adopt that, and if they get the Supreme Court to endorse it, it would make abortion illegal nationwide, because it would then be equivalent to homicide. That's sort of one approach they're taking. More specifically, and more to your question about the rest of these cases on Griswold, on Obergefell, well, Alito tried, whether genuinely or not genuinely, to sort of put some daylight between what he would rule in Dobbs and what the court might do in those cases. And I think that the degree to which you think he succeeded depends on the degree to which you think he is being honest there. If you think that Samuel Alito would actually vote to sustain Griswold or Obergefell, then sure, you can take him at his word on that. But I think that if you look at the logic he uses to reach this decision, where he says that rights that are not clearly rooted in the Anglo-American legal tradition don't have any constitutional validity, I think that it's hard to escape the logic of that sodomy laws, which had a long history in the American and English legal system, would not be able to come back. Same-sex marriage bans would be justified. Bans on contraception could come back. I think that the problem for this court is going to be trying to convince people that they have a limiting principle here.
Right.
When it's very hard for them to logically add one.
Yeah, let me give you an indication of how much honesty I think that we're getting from Alito. It's somewhere around here. But be that as it may, we will find out. And this is the thing that many people I don't think understand in terms of the implications of these cases. You can address a case and make it extremely narrow and tailored to that. But if you put within the reasoning of that case, you can write these things and say, but don't apply this to anything else, like we saw with the 2000 Supreme Court case, Bush v. Gore, where the court was adamant, do not rely on this case for any future case. They're sending this message to all the circuit courts and all the subsidiary courts in the country, which are all the other courts. And it simply has not been the case that case has not been cited. It's been cited multiple times.